Lord, may I mention item number 1?
Yes.
The leading counsel is out of his station. Seeking adjournment for 1
Who
week.
is the leading counsel?
Titi Tara.
Okay.
Kindly list
So
them.
your good name, please.
Koda Appa.
Goda
Appa.
Appa, learned counsel for the petitioner. Submits that leading counsel Mr. Titi Tara is out of station. Then as such, he pressed for listing the matter when?
After 1 week.
After 1 week. Fair load.
Your Lordship,
In the meantime,
May-
the
may I-
respondent authorities may file their affidavit in opposition.
may I please, Your Lordship, in this matter, Your Lordship, we need to file our counter affidavit, Your Lordship.
Pardon?
Yes, affidavit has not been filed yet, Your Lordship.
Okay, in the meantime,
need-
you file it
We need
1 week,
1 week will be too short, Your Lordship.
to sort.
Yes, Your Lordship.
You have received the instructions?
2 weeks, Your Lordship.
2 weeks. Okay, 2 weeks.
Grateful, my lord.
Yes.
Service 4 to 8 report.
Okay. I'll just-
Okay, sir.
Yes,
My
Mr.
lord.
Tago,
Yes, my lord.
service complete.
Yes, service is complete. My lord, whether from
You are,
VP was, my lord, VP was supposed to,
you are for
I'm for SIT, madam. Respondent number 3.
respondent number 3.
3.
we have taken a step on the victim, my lord. That's I believe it's completed.
Yes, my lord, VP, Office of the VP, regular VP was supposed to enlighten the court regarding the steps taken. State.
Anyway, since service is completed, now the matter will go to paperwork section.
My lord,
for preparation of-
that is right, my lord. One thing, my lord, in case if the after services after completion of service, my lord, the victims not represented by any counsel, they can be represented through the legal aid council, my lord. Right. And only, my lord, I filed the IA for suspension of sentence, my lord. My lord, that is, my lord, their presence is required, my lord.
Yes,
That's
yes.
only, my lord, in my whole cases, my lord, in the entire case, my conviction is based on the 5 witnesses, my lord, five victims, my lord. Although even if you take all the victim, their evidence as in toto, my lord, my respectful submission, my lord, no offense under abatement is made out, my lord.
Petition to be created. Petition to be created.
Accused has been convicted for abatement, my lord. 109 and 17, read with 21-2, my lord, of POCSO, my lord. So in my respect, even if you go by the evidence of the entire this victim, my lord, there's no element requiring the conviction of the accused, my lord. In the worst case, my lord, it can be a case of non-reporting, my lord.
Yes,
But this is not a case of abatement at any case, my lord. This is my respect. In the whole case, my lord.
that is also punishable.
Yes, it is punishable. Now, that is in case of non-reporting, in the worst case, it's non-reporting. In that case, the convict has already undergone.
Okay. Heard Mr. T. Tagum, learned counsel for the appellant. And also heard Mr.
L. Kurdu, SVP, SIT, my lord. Respondent number 3.
SIT. For respondent number 3. None appears for the respondent number
4 to 8.
1 and 2. 1 and 2, office note. 5. Indicate that
Lordship,
service interest of
I'm for the item number 3. I'm for the
You're for
item number
three.
3.
Your good name, please.
Connected.
No, no. Different.
Different.
Yes. You are for? Yes. Respondent number? 1. Respondent number 1. Respondent number 1, office note dated 1/4/2025 indicates that service upon respondent number 4 to 8 completed. But no one appears on behalf of the aforementioned respondent. Uh, Where is the list?
A list. Sir, respondent number 2, report to it. Respondent 2 to affected.
One appears for the respondent number 2. That 4 to 8. Is it the same judgment against which reference is also made?
2, 3, 4 and 5.
My lord.
Same.
Yes, my lord.
Okay.
Right,
This is in respect of other accused, my lord.
yes.
And my case is confined to, my lord, the abatement.
Yumkin, Bagar,
It is the main accused, my lord. It's a prime accused.
3, 4, 5.
Mr. Tagore,
My lord,
we'll wait for some time.
my lord.
No. Today we'll not be sending the matter for preparation of paper
My lord,
because we have received one reference,
my lord,
case reference. Here we have to issue notice.
my lord,
So we have to hear all the matters together.
my lord.
So list the matter after 2 weeks. And in the meantime, and the registrar shall put up one up-to-date office note indicating as to whether any council entered appearance by filing Wakalatnama for respondent number 2 and 4 to 8. 4 to 8, list after 2 weeks.
Keep your breath.
For example, heard, madam, your good name,
Dirilung, Dusurilung.
learned counsel for the appellant.
Yes.
Appellant, Mr. Hilpo, respondent number 3.
That's a 2, sir.
Respondent number
2.
Respondent number two.
Respondent
And
number
EPFO,
two, my lord.
What?
Two, my lord. One.
One.
One more.
One. Office note dated 28/5/2025 indicates that person to order of this court dated
26/3.
26
Three.
March 2025. Necessary correction has been made in the cost title.
Has not yet been corrected.
Madam, this correction is not yet been made.
Lordship, for that, we need some time for correction the cost title.
What's that? Cost title, necessary correction of the cost title is yet to be made. The Lord Council for the appellant submits that she may be granted some time to make necessary correction of the cost title. If there is accordingly allowed, this is a less than after 2 weeks.
2 weeks, okay.
That's why the corrections.
Yeah, all this here, one of the leading counsel is out of station, my lord. But we have taken steps upon the respondent number 3 to 24, my lord. And the notice is still awaited. And we also need some time to correct our cost title also. Cost title, there is a defect in the cost title, my lord. The husband of the victim has filed an appeal, my lord.
Okay.
Otherwise, my lord, for the victim and the other, my lord, there's ambiguous query, my lord. Can be appointed now.
Part Mr.
BP Chairman,
Council appearing on behalf of Mr.
appellant, my lord. J. Genie, my lord. My name is Dear, my lord. In the-
Zeni,
J. Genie, yes.
Learned Council for the appellant. This is also connected matter.
Yes, my lord.
Office note dated 28/5/2025 indicates that service report in respect of the informant. Respondent number 3 and respondent number 4 to 25 has not yet been received. So you have to take a fresh step then.
My lord, we will await, my lord. We will
Await.
wait, yes.
Okay. That's the matter after 2 weeks, awaiting
Vale.
service report upon respondent number 3 and 4 to 24. Mr. Pisa, Learned Counsel for the Learned Counsel appearing on behalf of Mr. Jazini, Learned Counsel for the petitioner, no, appellant submits that some correction has to be made in the cost title of this cost title of the appeal memo. Here is accordingly allowed. Usually, there is a notification of the High Court.
Yes,
You
my
have
lord.
to file on IA for correction.
Yes, we will file, we will file.
Okay. And he will file one interlocutory application for making necessary correction in the aforementioned cost title.
Right.
Here is accordingly allowed, list the matter after 2 weeks.
My lord. Oblige.
Oblige. This is a reference for the death penalty imposed by the learned special court, your lordship. Now, so your lordship, the provision of the CRPC and corresponding provision of the BNSS, it says, your lordship, if the appeal has been prepared then first appeal has to be heard, then,
They're not together.
yes, Your Lordship. Your Lordship, the provision is in BNSS, Your Lordship,
407.
BNSS, Your Lordship, from 40, actually it's 409, my lord. In any case submitted under section 407, the High Court may confirm the sentence or pass any other sentence warranted by law, or any annul the conviction and convict the accused of any offense of which the Court of Session might have convicted him, or order or new trial or same or amend charge, or may acquit the accused person, provided that no order of confirmation shall be made under this section until the period allowed for preferring an appeal has expired, or if appeal is presented within such period until such appeal is disposed of. That means it has to be heard together, Your Lordship. The after appeal only is to confirm.
So whether the person concerned is preferred an appeal,
Yes, Your Lordship. The earlier one, just with Karkin Bagra case.
which one?
Karkin Bagra matter, Your Lordship, which has, Your Lordship has passed the
Item
order.
number 4, my lord.
Item number 4, Your Lordship.
What's that?
They have already prepared appeal, my lord.
So we'll take this reference with that
Yes,
item
sir.
number 3.
Yes, Your Lordship.
Item. So heard, Mr.
Your Lordship, it will be also represented by the special PP only, Your Lordship. Special PP SIT.
SPP SIT, my lord.
Special PPSIT. This reference under section 366 stroke 366 CRPC, read it, section 407 of the BNSS 2023 is met by the district judge, by the section judge UPM. For confirmation of the death sentence awarded to convict Shri Yamken Bagra. Yamken Bagra. It is to be noted here that while interim judgment can order dated uh 26/9/2024. The learned special judge POCSO has convicted Yamken Bagra, Daniel Partin, Tazum Yerpen, and Srimati Morbam Namde Tape and Singhan Yerpen. Case number 2. The Daniel Partin to Tazum Yerpen. It is the Yamken Bagra, Srimati Morbam Namde Tape and Singhan Yerpen. And sentence. Yamken Bagra to suffer death and also 7 years under section sentence with under section 6 of the POCSO Act.
Appeal number 36/2020.
36 2024. Accordingly, it is provided that this matter shall be taken with the aforementioned appeal. List after 2 weeks.
Obliged.
Your Lordship, I beg to mention item number 4, Your Lordship.
Item number
4.
4.
Yes, Your Lordship. May it be fixed after a week, Your Lordship.
Mr. Y. Ram, learned counsel for the petitioner. Any objection?
No.
With consent from the other side, press for listing the matter after a week.
Yes, Your Lordship.
Okay.
And Your Lordship, there is an interim.
Interim order passed earlier shall continue.
Oblige, Your Lordship.
My lord, I beg to mention item number 6, my lord. My lord, here, I have not yet received the instruction from the department, my lord. Can this matter be released after 3 weeks, my lord? Consent from the other party, my lord.
I'm body petitioner, Mr. T. Tagum, learned standing counsel for Education Department. With consent from the other side, price for listening the matter after
3 weeks, my lord.
3 weeks. Yes, he has not received any instruction from the respondent authorities. Fair lord, this is a list the matter after 3 weeks.
Lordship, there's an interim.
Interim order passed earlier shall continue.
Deeply obliged.
May I please, Your Lordship? Lordship, there is a criminal petition number 202, which is similar to the item listed in item number 7, criminal petition, in the sense that both these cases are challenging the same FIR. This is for quashing of FIR. Now that case, criminal petition number 202 was listed yesterday before the learned single bench at court number 2.
So
So
both
therefore,
are to be listed together.
order has been already passed yesterday.
Yes, sir.
That, yes, that this case also may be listed with.
Okay.
So therefore, Lordship, this
Okay.
may not be taken up because it has already been checked.
Okay. What is the number of that petition?
202
202.
of 24.
24.
24, yes.
In respect of item number 7, you take down Ms. Dangan, learned counsel for the petitioner, submits that in connection with the same FIR, another criminal petition being criminal petition number 202 of 2024 has been filed before this court, or no, is pending before this court, and the same was listed before the court in advance of this court yesterday, and therein a direction was issued that both the matters may be listed together after
After
2 weeks.
2 weeks, after 2 weeks.
After 2 weeks. Accordingly, it is provided that this list this criminal petition number 201 of 2024 along with criminal petition number 202 of 2024 together after 2 weeks.
Oblige.
Oblige.
May I please, my lord? My lord, I beg to mention an unlisted matter, my lord, for withdrawal, man. To be listed to the man. My lord, I beg to mention an unlisted matter, my lord, for
When?
withdrawal. For withdraw, my lord,
When?
to the man.
Today? Okay.
I beg to mention one more item, my lord. Item number 9 and 10, my lord. The council, the leading council is our station. So matter may be adjourned for the time.
Or 9.
9 and 10.
Who is the leading counsel?
L. Gilen,
Mr. Your good name?
M. Ratan, on
Learned
behalf of
counsel-
L. Gilen.
Learned counsel appearing on behalf of Mr. Luktar Sinen Jilen. Learned conducting counsel for the petitioner submits that is out of station.
Our station.
And press for, and therefore it is spread that the matter may be listed after
3 weeks, man.
3 weeks. Parallel.
Deeply obliged.
Yeah, Lordship. I beg to item number 15.
Yes.
I'm for the respondent number 4 and 5.
Yes.
A matter may be listed after 3 weeks.
You will come to address it?
Yes.
Yes.
Any objection?
No.
Mr. Your good name?
He go.
Learned counsel appearing for respondent number 4 and 5 with consent from the person press for listing the matter after
3 weeks.
3 weeks.
Yes.
After 3 weeks. Parallel. All right.
Lordship, I would like to mention item number 12. Lordship, may kindly I've taken the concern of the petitioner, your lordship. 3 weeks may be granted, your lordship. I have to file affidavit in this case.
So, sir, learned counsel for the respondent authorities with consent from the other side. Price for listing the matter after
3 weeks, your lordship.
3 weeks, so as to enable her to file affidavit in opposition.
Your lordship.
Fair lord.
Obliged.
Your lordship, this, we had to file this requisition in haste, my lord. So, my lord, one notification, my lord, this notification could not be annexed. So we will be filing it shortly, my lord. It is the basis on which LPC in Arunachal Pradesh is issued, my lord. My lord, may I go through the notification first before starting my submission, my lord? This notification is the heart and soul of the LPC on the basis of which this writ petition has been filed, my lord. How the LPC is issued in Arunachal Pradesh, my lord? The government has been considering to evolve a signed by him has to apply to the government through deputy commissioner, my lord. And deputy commissioner, what he will do, my lord, he will send his land measurement land authorities, my lord, to verify the land. After verifying and preparing the map, my lord, more rigorous this exercise is carried out, my lord, like issuing notice to all the concerned village authorities, land boundaries who are adjacent to the land in context, my lord. Everything is done. After the completion of the this claim and objection, my lord, by the government, my lord. This is the procedure, my lord. This was issued in 19 December 1988, my lord, and it is still in force. And we will file it in a day or two, my lord. This we could not file. Or 3 p.m. here yesterday, my lord. That's why, my lord, we may be allowed to use it, my lord. And we will be filing it, or it may be taken as a record, my lord. My lord.
But Mr. Jano,
My lord.
you have filed this application under Article 226 also.
My lord.
So this bridge authority
My lord.
is the lowest forum, judicial forum.
My lord.
Whether a judicial authority is amenable to raise jurisdiction under Article 226.
My lord, my lord, that we will satisfy your lordship, my lord. My lord, Article 226 is this article, my lord, where this prerogative writs are this enjoyed by the Honorable Supreme Court, my lord, or Honorable High Court, my lord. There are particularly two writs, my lord. Two prerogative writs, my lord. One is prohibition, my lord. Prohibition is strictly for the lower court or tribunals, my lord. So Article 226 is amenable to the lower judicial functionaries also, my lord. Apart from that, my lord, law of this certiorari article, this writ of certiorari, my lord, that is also amenable to the lower judicial functionaries, my lord. So we will. And apart from
To my understanding, against the judicial forum is not 99.
my lord, 226, my lord, this
The decision of Supreme Court also.
my lord.
Decision of Supreme Court also. Of course, we can
It
proceed
is-
under 227.
Okay, my lord. Okay, my lord. The problem here is, my lord, it is an order not appealable, and even section 115 CPC, my lord, I have to come here in one instance. There might be some varying opinion, like I should approach the honorable court for this relief, my lord, under section 115. But 115 section CPC is applicable only for judicial order which has been tried and issued by the after trial, my lord. So it is an order, trial has not been begun, my lord. So may be taken up under 227 also, my lord. It can be taken up under 227 also, my lord. My lord. So, my lord, in Arunachal Pradesh, I have made my submission there with the basis of the notification in force, my lord. The government issues land possession certificate of land to indigenous person, my lord. And after ascertaining the claims and objection, titles and ownership, everything, my lord. And if PC has been illegally or wrongly issued or dubiously obtained by the holder, my lord, there is forum. They can go to the issuing authority, praying for cancellation, or if that is not done, Article 226 is always open for them, my lord. They can approach this honorable court for mandamus, my lord. And in some cases, this honorable court has also given some directions, my lord, in such cases to take up and consider, examine whether this LPC has been issued rightly or wrongly, my lord. And petitioner number 2 here is holding the land possession certificate, my lord, and it has been annexed in this annexure 1. Page 18, my lord. Page 80. 18.
Yes.
Yes. This is to certify that an area measuring 343638 square meters as described below is possession of Sri Tigao, son of late Tigao, village Zarkong POPS, district Eastern Arunachal Pradesh, and the same area plot is free from all encumbrances as per the available records on that, my lord. So this, my lord, this LPC was issued after following all due process of law. And Village Kebang, customary court, my lord, has no jurisdiction or power at all to annul, amend or alter or pass any order overriding this LPC unless this is set aside or recalled, my lord. My lord, respondent number 3, the complainant here, and the respondent number 5, the head Gambura Kebang, are close relatives, my lord, or same village, my lord. They have clear knowledge about the existence of this land possession certificate, my lord. They have clear knowledge because there are 3 instances that this fact has been brought into their knowledge, my lord. 3 instances. Number 1, a legal notice has been served on them stating that this land is not belong to private petitioner, number 1. It belongs to petitioner, number 2. By the virtue of the duly issued land possession certificate issued by the government. So you cannot initiate any suit or kebang against me in connection to this ownership and title over that plot of land, my lord. That has been done. Number one, my lord, it is in page number 3,
How the petitioner number 1 is aggrieved?
my lord. Keba, proposed keba.
No, petitioner number 1.
Yes, proposed keba, Tugaru keba is proposed against number 1. It is number 1, my lord. Tomorrow's
No, land possession certificate was issued in favor of the
petitioner number 2. Petitioner number 2.
Oh.
But what he did, my lord, notice has been issued, someone has been issued to the respondent number 1, saying that
No, petitioner number 1.
petitioner number 1, my lord. Please come to page number 27, my lord. Page number 27. Is in Adi, my lord. So we have this translated it in page number 29. May I read? Page number 29. Two Sri Olom Perme, son of late Gatling Perme, Berung Biles, came to Pasigat Mile. It is the petitioner number 1, my lord. Versus Sri Otindai, Okalidai, and another petitioner, complainant Sapogdai, my lord. Sri Totindai being sick on his delegation, the complainant dated 1/3/2025 regarding the Tulap land summoned dated 8/3/2025, 12/4/2025 were issued in the name of Sri Sapogdai. Now Sri Otindai is fairly well and that in the village land allotment list, Tulap is in the name of Sri Otindai. Hence, it was appealed that the name of complainants name may be given jointly in the name of Sri Otindai and Sri Sapogdai. Hence, on the basis of their appeal, henceforth, summons shall be issued as Sri Olom Perme versus Sri Otindai versus Sapogdai. Date on which summons were issued from my office. Dated 8/3/2025, Sri Olom Perme informed in written that he is not in position to attend Keva on 13/3/2025. Dated 8/4/2025. On that day, BBGB picnic was conducted. Hence, there was no Kevang held. On dated 12/4/2025, on that day, Sri Olom Perme did not attend the spot of Kevang. However, the Kevang members visited the boundary and recorded. Sri Olom Perme came to Bile versus Otindai Mongkudai. You are hereby summoned again because for the Tulap land case, summon has been issued thrice. However, not taking the first to summon dated 12/4/2025, wherein Kebang was made together without your presence, that summon is being treated as second summon. You are directed to attend in Kebang on that time and venue fixed herein below with your witnesses, documents, etc. 9:30 a.m. Village Balak Community Hall in their village, my lord. Tomorrow, that 35/2025, my lord. Your lordship, prior to this, my lord, I have clearly informed them that this is no more my land. It has been sold by me a long way in 2019, and land possession certificate is issued in 2023, my lord, in the name of this petitioner number 2, my lord. That is also very much in their knowledge, my lord. And it was given, my lord, that I have intimated, my lord, in page number 22, my lord. Page 22. I have clearly stated there, through my counsel, my lord, page 23, paragraph number 2, may I read, my lord, that my client further enlightened that the landed property which you fraudulently claim azure was my client's forefather's property, and later on same was succeeded by him. The same property was under absolute possession of my client family since time immemorial without any disturbance from any corner. Since the said landed properties legally belong to my client, so he sold the same to Sri Tatergao, son of Len Talogao, for its legal requirement. That land possession certificate against the said landed property has also already obtained by the Gao family from the office of the Deputy Commissioner Pasighat, duly following the procedure established by the law, and is now under the absolute possession, my lord. Complainant was served this notice, legal notice, and he was clearly informed, my lord. Apart from that, my lord, please go below. Please come below, my lord. Copy to Otik Dai, the Gambura, who is repeatedly issuing this summon, my lord, was also personally served the copy of this notice and described in the language understood by him that you have no jurisdiction to try this suit regarding determination of ownership and all, which is covered by this land possession certificate, my lord, unless that is this challenge and get annulled, my lord. In spite of that, my lord, this petitioner, plaintiff, my lord, or respondent, my lord, respondent number 5, he on dated 25/4/2025, my lord, 25 April, my lord, he forcefully entered into the LPC land and constructed one Kacha house, my lord. So, being agreed by that, my lord, this petitioner number 2, my lord, lodged an FIR, my lord. It is posted in page number 24, my lord. Here also, he got to know that it is under this LPC, but case was not registered on the understanding that he assumed that, okay, I will create no further disturbance. Accordingly, police went to the spot and removed the structure he put there, my lord, on the same day, and matter was left that way, my lord, because police also informed him, see, LPC is here. So first you go and challenge it, then you can do whatever you want. So instead of this exhausting his available remedies, my lord, what he is doing is he just want to bring the petitioner number 1 in his village under the kebang of his relative, so that this adverse order is passed against me tomorrow, my lord, at his village, my lord. It is obvious, if it is not this interfered with, my lord, the apparent result that will be coming for tomorrow will obviously be adverse to the petitioner number 1, who has no interest in the land, my lord. Your lordship, from page number 24, second time, he was informed by the police that you see he is having valid land possession certificate. After that, my lord, still on page 25, my lord. After all this, my lord, what this petitioner respondent number 5 is doing, my lord, just he want to urge out some adverse order from his relative, this Gamburas, my lord, against petitioner number 1. What he has done, it is in page number 26, my lord, translated copy. After all this, my lord, page number 30, page number 26, on dated 30/4/2025, my lord. Whereas on 25, I lodged an FIR, and here also he got to know about the LPC, my lord. Again, he writes to the same GB, my lord, whom we have informed about this LPC, my lord. Through this letter,
Okay, let notice go at this is this
my lord, we have this
interim prayer.
interim prayer for this staying
Yes,
of the
madam.
because our submission is, my lord, clear.
Yes, actually, your lordship, LPC has already been issued to the petitioner, your lordship.
Mm.
And if the private respondent has any grievances, he should have approached the DC, your lordship, issuing authority,
Under
and not to the
who
Gawai,
has
your lordship.
issued the LPC.
Yes, your lordship.
Heard Mr. Jamal, learned counsel for the petitioner, and Madam Basar for the respondent authorities. In this petition under Article 226 and 227 of the Constitution of India, the petitioner has challenged the authority of the
Impugned some 23/5/2025, my lord.
challenge the authority of the Gambura,
My lord, Gambura.
Balek Blaze, Pasigat.
My lord.
In issuing the summon dated 23rd 5 2025 to the petitioner number 1 and petitioner number 2.
No, petitioner number 2 has not been issued, my lord.
Okay,
Only
petitioner
one,
number 1.
my lord.
Petitioner number 1 in respect of one complaint dated 1st of March 2025 regarding Tulap land. Mr. Zamo further submits that
My lord.
in fact, the petitioner number 1 was the original owner of a plot of land in respect of which LPC, land position certificate within bracket LPC, was issued by the government on when it was issued. In respect of the petitioner number 1.
In petitioner number 2, my lord, it was issued on 29 December
No, in
2020.
respect of petitioner number 1.
No, in petitioner number 1 didn't take out LPC, my lord. He was not having
LPC was not issued in his name.
No, he didn't apply, my lord. In
Okay.
Arunachal Pradesh, most of the
Though
people are not
he was
applying.
the owner of the land, LPC was not issued in his name.
No, he didn't apply, my lord. In Arunachal Pradesh, my lord.
Petitioner number 1 is the owner of a plot of land.
Yes,
Where you have described the land,
your lordship.
where you have described the land.
My lord, here, it is in page number 18, my lord. And map is there, my lord. Map is in page number 19, my lord.
Hmm.
It is a government map, my lord.
Measuring 3,438 square meter.
My lord, yes.
And subsequently, the petitioner number 1 sold the aforesaid plot of land to the petitioner number 2.
My lord.
And thereafter, the government has issued LPC,
My lord.
Annexer 1.
Yes, my lord.
Annexer 1 of the petition in favor of the petitioner number 2.
My lord.
Thereafter, dispute arises in respect of the said plot of land between the petitioner number 2 and
No, my lord, petitioner number 1 and
petitioner
respondent number 5, my
1,
lord.
petitioner number 1 and respondent number 3.
5, my lord. Respondent number 5.
In respondent number 5.
My lord.
And thereafter, the respondent number 5 lodged one complaint with the Gambura.
Gambura, respondent number 3, my lord.
Respondent number 3,
Right.
Gambura, or Balek Place, Pasigat,
My lord.
the respondent number 3. And thereafter, the respondent number 3 to settle the dispute between the respondent number 5 and petitioner number 1 has issued summon to the petitioner number 1 for deciding the matter on 30/5/2025 at Balek Community Hall
My
at about 9:30 a.m.
My lord.
9:30 a.m. Mr. Zamo further submits that if there is any dispute in respect of the LPC, there is authority to deal with the same. That is the authority who had issued the said LPC.
My lord.
But the respondent number 3, the Gambura, has no authority to decide the LPC, decide the legality or validity of the LPC issued in favor of the respondent number 2. No, sorry, petitioner number 2. Petitioner number 2. And as such, Mr. Zamo submits that the impugned summon issued to the petitioner number 1 may be state. Ms. Basser, learned counsel, learned government advocate for the respondent authorities also fairly submits that if there is any dispute in respect of the issuance of LPC, then there is authority to deal with the same. And Gabra is not the authority to deal with the dispute in respect of the LPC. Fair. Having heard the submission of learned counsel for both the parties, I have carefully gone to the petition and the documents placed in record, and also perused the Annex R1, the LPC, and also the summon, which is enclosed with the petition at page number 29. Page number 29. The submission so advanced by learned counsel for both the parties needs further consideration. At this stage, notice be issued to the respondent, returnable in 4 weeks. Since Ms. Basser entered appearance and received notice on behalf of respondent number 1 and 2.
Yes.
1 and 2. So no formal notice is required to be issued. However, extra requisite copy of the petition may furnished to her during the course of the day. Step upon respondent number 3, 4, and 5 be taken by registered post with AD and also by usual process within a week from today. Pending further consideration, the IPM notice dated so and so, then stay till returnable that list of reports.
Obliged.
Number 2.
Lordship. Lordship, we are the members of a community-based organization belonging from Yobin tribe on Vijayanagar circle. We are a population of only 5 to 6,000. Representing our community, we have a community-based organization. And we are in functional for 3 decades. It was established in 1985.
Yes.
Lordship, after the due process of all the election process by nominating chairman and a representative from all the villagers, we have selected our own representative. And thereafter, a complaint has been made by a few members of the society itself and before the district administration. And the district after that complaint, the district administration intervenes in the proceeding and functioning of the society, the community-based organization, and passes an order to keep the abeyance of the oath-taking of ceremony of the organization. And thereafter, he directs the community to form. And thereafter, after formation of the interim committee, he himself forward the same complainant to be the member of the registered society. And despite of several complaints made by the members, the aggrieved members with the petitioners, the district administration have forwarded the registration process. And we have also made a complaint in the register of the cooperative society. Despite of that, they have registered a society in the name of our community-based organization. Your Lordship, we
Where
have
is the notice?
Lordship.
Where is the order, impugn order?
Impugn order is, Your Lordship, page number 8, page number 68, annexure 8.
So this is the
Lordship.
order issued in the year 2022.
22, Your Lordship.
22.
Yes. Despite of several complaints made by the society members, they have willingly forwarded the registration of all the certificates to the registered cooperative society.
Pardon?
We have met several complaints not to register the society as the case is pending before the district administration. Despite that, they have forwarded the same order copy to the registered society. Your Lordship may please to see complaint made by our community-based organization. Page number 202, Annex 12.
Okay, at this is let notice go, we will see. Yes,
This day only notice.
notice.
Actually, that was properly registered long time back in 22. Now they are coming to court.
Okay, heard Mr.
Titatak.
Learned Counsel for the petitioner and Mr. N. Long, learned senior government advocate for the state respondent. In this petition under Article 226 of the Constitution of India, the petitioner has challenged the correctness or otherwise of the order dated 27/5/2022, issued under a memo number M/JUD-31/MISC/PT/6846-905, passed by the ESC, within bracket JUD, ADC Miao subdivision, district Sanglang, and also the certificate of registration being SR/ITA/7437, dated 21st of November 2022, granted by the Register of Societies Govt of Arunachal Pradesh. Peruse the petition and the documents by some record, and also peruse the order, impugn order dated 27/5/2022, and also the registration certificate dated 21/11/2022. Let notice be issued to the respondents, returnable in forest, they be taken by registered post. No, however, no formal notice is required to be issued since the respondent authorities are represented by Mr. N. Long, learned.
We responded only my name. It has elected.
Respondent number 4.
Yes.
Okay. Issued to the respondent number.
The same copy has been served to the Deputy Commissioner also, Your Lordship. Respondent number 4 is the ADC, Additional Deputy Commissioner.
And there are numbers of other private respondents.
23.
However, no formal notice is required to be issued to the respondent number 1, 2, 3, 1, 2, and 3, since Mr. N. Long, learned senior government advocate, entered appearance and received notice on their behalf. However, extra requisite copy of the petition will be furnished to him during the course of the day. Notice to the rest of the respondent be issued by registered post with AD and also by usual process within a week from today. List the matter after 4 weeks.
Lordship, 1 week.
In the meantime, Mr. Loang, learned Senior government advocate shall obtain necessary instruction. Yes,
Lordship, 1 week time may be given for to serve the notice. There are 22 respondents. Will take
1 week,
yes,
4
at
weeks.
least 1 week to prepare this notice.
We are giving 4 weeks. 4 weeks. Now to prepare notice within 1 week.
Yes, 1 week.
Okay. This will be taken by registered post with ADM also by user process today. List after 4 weeks. Is there any interim pair?
Interim pair is, Your Lordship,
Okay, interim pair of the petitioner will be considered on next returnable date. List after 4 weeks.
most obliged.
My lord. My lord, I am preparing for the petitioner, my lord.
May I?
You are for?
Your Lordship, I'm appearing on behalf of DSGI, Mr. M. Kato, for respondent number 1. Your Lordship,
Lord,
in this matter, respondent
let
number
me-
2 and 3 are the principal
me-
parties concerned.
Let me
We are
address,
performer respondent.
let me address, my lord. My lord, I am appearing for the petitioner, my lord. The respondent number 2, my lord, awarded the contract in favor of the respondent number 3, and the respondent number 3 awarded a subcontract to the respondent number 4, my lord. My lord, I will not supply the goods to the respondent number 3, 4, my lord, for use in the main contract, and for the payment of the same was made by the respondent number 2 in respect of the entire work. Now, my lord, the respondent number 4 was not making payment of a sum of rupees 2 crore something to the petitioner, and thereby petitioner addressed a letter to the respondent number 2, pointing out that the payment has not been made by the subcontractor. Now, we'll also kindly see the response to took cognizance of the same, and will inform the petitioner by letter dated, which you'll also find at page 559. 559, my lord. Also got in, my lord. Annexure 8,
Yes.
559. You'll also kindly see, my lord. This was a letter addressed to the contractor, my lord, by the respondent number 2. I read para 1, my lord. In reference to a letter, in reference to the letter mentioned above, which so and so has intimated this office regarding outstanding payment of rupees so and so for the supply of bitumen material on credit to your firm for construction of so and so. As per the email of the bitumen, that is the petitioner, my lord, they continuously reminded your firm a follow-up emails and request for release of the outstanding payments, but your firm has not responded to any of the communication regarding the overdue payment. In this regard, this office directed your firm to pay the outstanding amount directly to the petitioner, that is petitioner, and submit NOC to this office within 15 days. If your firm fails to pay the cost of the bitumen and did not obtain NOC from so and so regarding the outstanding amount, then the amount of rupees so and so will be deducted from the upcoming SPS for release of the same directly to the supplier. In case no SPS IPC forthcoming, your BG will be encashed and the amount will be directly paid to the Bitumen India Limited for their outstanding amount, that the petitioner, my lord. In this regard, you are hereby directed to make payment to the Bitumen so and so within 15 days from the issue of the letter. Further, it may be noted that the reminders of this outstanding amount frequently intimate to third parties of the office, which is damaging the image of the organization, which is not good for the industry practice done by the so and so. So, my lord, the respondent number 2 wrote to the contractor that this amount is outstanding and the same should be paid to the petitioner directly. And in case the said payment is not made, then the said amount shall be deducted from the payment due to the respondent number 2 and by encashing the bank guarantee, and thereafter the payment shall be made to the petitioner. Now, after this, my lord, the petitioner has written 2-3 mails to the respondent number 2, pointing out that the payment has not been made in spite of the direction issued by the respondent number 2, but no action whatsoever has been taken by any of the authorities. Now, my prayer in this petition is there, my lord, that Lordship may issue rule and your Lordship may see my interim prayer at page 26, my lord. Page 26, my lord. And your Lordship got it, my lord, page 26.
Yes.
My lord, pending disposal of the rule, your Lordship may further be pleased to direct the respondent authorities to respond number 2 to hold an amount equivalent to the legitimate dues of the petition amounting to so and so, and keep the bank guarantee submitted by the petition number 3 with the respondent number 2 alive pending disposal of the petition. Because, my lord, if the entire payment is made, then nothing will remain for the petitioner to do. So we are not saying that the amount should be transferred directly to us. We are saying, my lord, during the pendency of this petition, at least till the response comes, this amount should be kept and should not be made to the respondent number 2. Otherwise, the letter written by the respondent number 2 to the respondent number 3, there will be no meaning. So your Lordship may kindly issue notice, and this amount may be kept at least alive, may be kept reserved with the respondent 2. We don't want that you make the payment to us before any response comes. But if nothing remains with them, entire payment is made, then nothing will remain, my lord. And this is the direction of the respondent number 2 itself. In the letter, my lord, 550, my lord, 9, the respondent number 2 had clearly said that if the payment is not made, the same shall be deducted and the payment shall be made. But at this stage, I'm not saying that the payment should be made to us till your Lordship considers the petition, but that amount should remain at least, otherwise nothing will be there, my lord.
No, you tell me, there was a contract between the petitioner and the respondent number 3 and 4,
4, my lord.
right?
My lord, 2 has given a contract to respondent number 3, and 4 was the subcontractor of the respondent number 2. 3, my lord. But the entire payment of the work is made by the respondent number 2 to the contractor. Even for the work done by the subcontractor, also the payment is made by the respondent number 2 only. Because the contract is between respondent number 2 and 3, my lord, only. No, am I audible, my lord?
Resume at 2 o'clock.
My lord,
We have one reference. We will join from VC. At 2 o'clock.
2 o'clock, my lord.
Item number 3.
My lord.
Yes.
In a short, my lord, reference has been done, I think.
Yes.
My lord, what I was submitting for Lordship, my lord, that the respondent number 2 gave a contract to the respondent number 3, and 3 gave to the subcontract to the respondent number 4. Now the entire payment has to be made by the respondent number 2 to 3. Even in respect of the subcontract, the payment is made by the 2 to 3. Now, when the payment was not made and the payment is not disputed, it is admitted, then the respondent number 2 himself, my lord, at page, Lordship has seen the page 559, have specifically stated that if the payment is not made and NOC is not issued, then the amount will be deducted from the payment of the contractor and the payment shall be made to the petitioner.
Yes.
Now, that having not been done, my lord, I have approached this honorable court, and my prayer is only that, my lord, if the entire payment is made in the meantime, then the petitioner will have no other option, but, my lord, the petitioner will be, my lord, nowhere. So my prayer is that, my lord, only notice may be issued, and Lordship may direct the respondent number 2 to keep this amount reserved with them. I don't want that in the meantime to make payment to me. At least this amount they should keep with them only, my lord. And in the meantime, if they make the payment, they will get the payment.
Okay. Yes, Mr. Kato.
Madam, I am for the respondent number one only, madam.
Hmm.
The respondent number two and others, they are having their madam own panel council. And case wise, they are allocating their panel council.
Hmm.
So therefore, madam, at this stage, madam, I cannot accept notice on behalf of respondent number two and three, madam. But
We'll
two
take
and
it.
three, madam.
We'll take this.
Especially two, madam. Respondent number three is the private respondent and four is also private respondent. I can accept notice on behalf of respondent number one only. And respondent number one has no, madam, as part of the meeting, madam, no role to play, madam.
No,
Basically,
respondent-
it has been done by the respondent number two, madam.
Well, respondent one is a formal below because Union of India has to be a party below. That's why they are below the independent party.
You can represent respondent number two.
Madam, yes, madam, but as per the instruction issued by the, madam, the Ministry of Law and Justice, madam.
Hmm.
Madam, what happened in this bench, madam? In all cases, madam, they are appointing as per their own choice, lawyer. But as per the ministry guideline, madam, where the Union of India is a party, then, madam, the DSA and the council appointed by the ministry has to be appeared, madam. But here separate, madam, case wise in separate manner, madam, they are keep on appointing their own council, madam, which is against that.
We'll issue notice below by register post.
Madam, that this is that I can receive on behalf of madam, them, or notice may be directly issued to the respondent number
No,
two.
regarding interim pair.
Interim period, madam, in that case, madam, may I pray that, madam, the matter may be listed tomorrow. In the meantime, I'll come with the instruction,
Tomorrow.
madam. That's
Well,
because since I am not authorized.
I think below the interim prayer, nobody is being harmed below. Neither respondent number one, two, because we are not getting the money. We are not getting the money from the respondent number one.
Still then, madam, since.
The amount is,
Interference of the order passed by, madam, the authorities.
not
So
just-
one opportunity is, madam, at least,
The lawsuit is
madam, I'll come with the, madam, by morning, madam.
Mr. Sir, let us do one thing.
my lord,
We will list the matter tomorrow.
my lord.
In the meantime, Mr. Kato will obtain instruction tomorrow
As your lordship.
in respect of interim pair.
But according to me, Lord, no, I'm totally up to your lordship. Lord. But what your lordship is then, whatever their letter is there, that is your lordship is saying. Your lordship is not giving an interim prayer. Whatever they have said in the letter, your lordship is not giving the interim prayer at your own lordship. Lordship, whatever.
Mr. Saraf,
My lord.
what Mr. Kato has contended is that respondent number two has its own council, standing
No,
council.
no council, my lord. They said no council, they appoint councils. There is no standing council.
Whether anybody is available here for respondent number two.
For respondent number two, madam, the case wise, they are allocating.
That's why
madam.
there is no
Mr.
standing
Niti
council.
Tara is also, madam, the council for the other part, madam, respondent number two. Madam, and Ojing Pada, so many, madam, others lawyers are the panel council of this.
So there is no standing council. They allot the cases.
Let us do one thing. Tomorrow you will obtain instruction
lord.
in respect of interim pair.
Yes, ma'am.
Dr. Saraf, tomorrow we will list the
My
matter.
lord, as
Yes.
your lordship, I'm nothing below. Absolutely.
Okay. Otherwise, there is no problem in issuing notice, but in respect of interim pair, without any instruction and without hearing the other side, I find it difficult to
Well,
pass
in
the
fact-
interim order.
In fact, their letter, on letter, how they can go away with.
Okay, in the event of non-availability of instruction, tomorrow we will consider it.
My lord, as your lordship.
Okay, okay. Heard Dr. Ashok Saraf, learned counsel for the petitioner. Assisted by Mr.
Pritam Barua.
Interbarua, learned counsel for the petitioner, and Mr. M. Kato, learned counsel for the respondent number one.
Yes.
Mr. Kato submits that he can only represent respondent number one as per direction of the Department of Justice,
No,
Government of India.
One of my contention is where Union of India is made as a party,
Hmm.
madam, the organization comes, the ministry, any ministry, madam,
Hmm.
then I can represent, madam.
Hmm.
But the department, madam, department and some various other organizations, what they are doing is, they are, madam, engaging their own representation, madam,
Hmm.
which is against the guideline issued by the Ministry of Law and Justice.
Ministry
Where
of Law
Union
and
of
Justice.
India is a party, my lord.
Okay.
One of the DSA or the.
Okay, since no one is appointed in this case, you obtain instruction. Uh, since none of the council entered evidence for respondent number 2, it is provided that Mr. Kato, learned Deputy Solicitor General of India, shall obtain necessary instruction in respect of the interim period of the petitioner. Place the matter tomorrow at 2 p.m. then. Dr.
My-
Saraf at 2 p.m. tomorrow.
As your lordship, will, as per your convenience of lordship, will,
Okay, 2 p.m.
Fine. Leave the.
I am obliged, Lord.
Your Lordship, here we have not yet filed our affidavit, Your Lordship.
Whether the counsel for the petitioner present?
Yes,
He was
morning
present.
presence, he was present. One of his associates were present. Your Lordship.
What is the name of the council?
Sonam Somo,
Sonam Somo.
Somo.
She was present.
Yes, he was
Present.
present.
Heard Miss Sonam Somo, learned for the petitioner, and Mr. Y. Yegap, learned counsel for the respondent number
1 to 4. 1 to 4, Your Lordship.
1, 2, 3.
1, 2, 3, and 4.
1, 2, 3, and 4. Director, BFO. Again, Mr. Kato then, Hello?
Yes, Your Lordship.
for the road organization. Can I inform Mr. Kato? Mr. Kato and Kato respondent number 5, 6, 7, and 8. Mr. Riram, learned counsel for the respondent number 1, 2, 3, and 4 submits that. Have you received instruction?
Pardon, Your Lordship.
Have you received instruction?
Not yet, Your Lordship.
Submits
I have
that.
received, Your Lordship, from the
You
Deputy
received-
Commissioner, but he has vetted to the Land Management Department. That's why we are unable to get
Okay.
a Paravis comment, Your Lordship.
Though he has received, no, he has already received instruction and prepared the affidavit and sent it for vetting by the Department of
Deputy Commissioner to the State of Land
Commissioner?
Management. Deputy Commissioner has vetted in the Department of Land Management, Your Lordship.
Land Management.
Yes, Your Lordship.
Send it to Land Management Department.
Yes, Your Lordship.
And the Deputy Commissioner, respondent number,
Uh,
respondent number
4, Your Lordship.
3. No, respondent number 4
Yes, Your Lordship.
has sent the same to the Commissioner, respondent number 2.
Director, your,
Respondent
3, Your
number
Lordship.
3.
Yes, Your Lordship.
Respondent number 3 for vetting. And as such, he may be granted some time to file the same. There is accordingly allowed recess and lays the matter after
3 weeks, Your Lordship.
3 weeks. After 3 weeks.
Yes, Your Lordship. Here also, Your Lordship, same prayer, Your Lordship.
Same pair.
Yes, Your Lordship. We have received the Paravis comment, Your Lordship, but we need some more clarifications, which is why, Your Lordship, I'm praying some more time, sir.
Heard me, sir?
Okay, Taban Lordship. Lordship, here, Lordship, in the month of January, there was given the last chance, Lordship, for filing a affidavit, Lordship.
When? When?
In the month of January,
When last, Mr. Kato,
last chance was given to the government lordship.
yes, so in one matter, BRO is a party, respondent. So you obtain instruction?
In BRO, my lord, I can directly appear, my
Yes,
Yes.
I have recorded your presence.
My lord. Copy has not been served. Oh, my lord, I'm sorry, my lord. In this case, my lord, the Paravai's comment has already been filed. Then I will send back for the special, my lord.
Yes,
And it will take another, my lord, still to 4 weeks time, my lord.
we have granted 3 weeks time,
My lord.
3 weeks time. In respect of Mr. Kato, you take down. Mr. Kato, the learned counsel for the respondent number 5, 6, 7, and 8 submits that he has already received Paravai's comment and send us in for vetting. No, and prepared affidavit and send us in for affidavit, and it's 3 weeks time for filing the same, filing the affidavit in opposition, where is accordingly allowed. Rest is the matter after 3 weeks. Earlier matter. Earlier.
We'll try to file all of before.
Yeah.
Paravai's comment is already been said.
Okay, okay.
Much of it. Leave the way.
Mr.
Ketabang lordship.
Learned counsel for the petitioner. And Mr. Wairam, learned counsel for the respondent number
1 to 5, your lordship.
1 to 5. 1 to 5. Mr. Wairam submits that he has received instruction and prepared affidavit in opposition and send us in for vetting, and a price for granting him 3 weeks time, where is accordingly allowed. Whether service completed in respect of other respondent?
Lordship completed lordship.
Completed.
Completed lordship.
Completed. 6, 7, 8, 9, 10, 12. Completed.
Or completed lordship.
List the matter after 3 weeks.
Obliged, your lordship.
Hmm.
My lord, I would like to withdraw this writ petition, my lord.
Withdraw.
Yes.
Why?
My lord, now these petitioners do not want to pursue the matter. Petitioners do not want to pursue the matter.
Okay, okay. Mr. B. Pisa, learned, heard Mr. B. Pisa, learned counsel for the petitioner, and Mr. Reram for respondent authorities.
1, 2, 3, and 4.
1, 2, 3. Mr. Pisa, learned counsel for the petitioner submits that he has the instruction to withdraw this petition, as the petitioner is not willing to pursue this matter. Accordingly,
My lord, liberty may be granted.
here is allowed. No, accordingly, Mr. Pisa is permitted to withdraw this petition. However, liberty will remain with the petitioner to approach this court again by filing appropriate petition.
My lord, deeply obliged.
C. Modi, whether C. Modi is present. Next item. Yes, Mr. Sering.
So there are private respondents also in this case.
Because otherwise the issue is very limited, my lord.
Hmm.
Whether an eviction order can be passed,
Pardon?
whether an eviction order can be passed by the magistrate without issuing a show cause notice.
May
That
I
was the
please,
only.
Your Lordship? Lordship, I'm preparing for the official respondents, Your Lordship. We are yet to receive our instructions, Your Lordship.
You have a respondent number?
Your Lordship,
Number.
Mr. Singh, whether the service completed in private respondent?
Yes, my lord, completed.
Completed.
They are on record, my lord. They have filed the wakalat number also.
Okay,
Their names has been reflected in the cause list.
okay.
1 and 2, Your Lordship.
1 and 2.
Yes.
1 and 2. Why not 3? 3 is the
One-
officer in service.
1, 2, 3.
3. With officer in charge, Mr. Yes.
Yes,
Your
you have to.
Yeah.
Heard Mrs. Zesing, learned counsel for the petitioner, and Miss one more.
Miss, please and
Learned
title.
counsel for the learned government advocate for respondent number 1, 2, and 3. 1, 2, and 3. None appears for the
Your Lordship, I'm appearing for
Oh, you
private
are-
respondent.
4 and 5.
Yes.
Ms. T. Rimi, learned counsel for the respondent number 4 and 5. Respondent number 4 and 5. You want to file a affidavit?
I have not filed yet, Your Honor. I need some more time to file.
Some more time. Next one more learned government advocate submits that. She has not received any instruction. You have received instruction or not received?
Yeah, we have received the instruction for to file.
Okay, that she has received instruction. And she will bring the same on record by filing affidavit in opposition, and she prays for granting her 2 weeks time. 2 weeks time, fair allows. Ms. Remy of learned counsel for the petitioner. No, sorry. Respondent number 4 and 5 also submits that she may be granted some time to file affidavit in opposition. Fair is accordingly allowed. Rest is alleged the matter after 3 weeks.
Well, in the meantime, interim may be continued.
Okay,
Interim order.
interim granted.
Yes, my lord. Staying the impugn order.
Interim order passed earlier shall continue.
Duly obvious.
Yes.
My lord, I'm appearing for the first time. I'm filing my wakalat number today on behalf of respondent number 4, man.
My lord, item number 16, my lord, on the last occasion, this honorable court has directed me to produce the qualification of the private respondent.
Mr. Modi, you are for
Private respondent.
Private respondent, respondent.
who is personal and
N. Pada, Nalopada.
Nalopada.
Yes.
Is he present in the court?
He was, my lord.
He was.
Yes.
Then after some time, inform Mr. Pada.
Yes,
After some time.
my lord.
Next item.
May your lordship.
Hmm.
Your lordship, the order I have put to challenge is the order passed by the additional deputy commissioner
Hmm.
dated 26/5/2020.
My lord, conducting counsel, Mr. D. Pangan is legs in court too, my lord. Can it be pass over for timing, my lord?
Okay, let him come.
Obliged.
May I please, Your Lordship? Your Lordship, in this matter, Mr. Lemi Bang, who is the conducting counsel in this matter, is out of station. So I humbly pray this matter may be adjourned for today, Your Lordship.
Heard, Mr.
I bam, Your Lordship.
Ibam, learned counsel appearing on behalf of Mr.
Elbam, Your Lordship.
Elbam, learned conducting counsel for the petitioner. Petitioner submits that Mr.
Elbam.
Elbam is out of station.
Yes, Your Lordship.
And as such, a press for listing the matter after
2 weeks, Your Lordship.
2 weeks.
Yes, Your Lordship.
Miss
E permit.
E. Parmi, learned
Respondent
counsel for
number-
the
Private respondent number 4 to 20.
private respondent number 4 to
20.
20. And Madam Wangmo?
Your Lordship, P. Sangita. My name is P. Sangita.
Your name is P. Sangita, sorry. P. Sangita, learned government advocate for respondent number
1 to 3, Your Lordship.
1 to 3. 1 to 3. Present. List the matter after 3 weeks. After 3 weeks.
Much obliged.
Right.
Online can request this request
When none appears for the petitioner on call, list the matter after 1 week.
Made legal. My lord, I am appearing as a amicus curiae. So here, my lord, criminal application number 05/2005 filed by the accused, Sri Hemanta Boragohain. My lord, the fact of the matter is that an FIR was lodged by one Miss Purobi Mangkung. And actually, page number 1 is the FIR.
Page number 1.
One of the my paper book. Paper book.
Yes.
Addressed to the officer in charge, police station Namsai. Subject FIR. Sir, may I read the contents of the FIR, my lord? It is to inform you that today on 16/3/2021, while I was at home, my domestic helper, Miss Tara Mansai, aged about 15 years, came back to house from my sister's house, and as soon as she entered the house, took a bath and silently sitting inside the room in the dark. On my query, she disclosed today on 16/3/2021 at around 6 p.m. when she was coming back to home from my sister's house, one person who is working at sawmill located at Lathao village had pulled her forcibly towards the jungle and closed her mouth with white gamsa and raped her. Further, the culprit is identified as Sri Hemanta Boragohain, son of late Sanjeev Boragohain of Dola, Assam. Accordingly, both the victims and the culprit have been brought to police station for further necessary action matter. This is matter FIR, and in pursuant of the FIR, the IO of the case investigated, after registering the case, investigate the case. And during the course of investigation, my lord, altogether 5 prosecution witnesses and their statements were recorded. And under section, it was registered under section 41/376 IPC, read with section 4 POCSO Act. For the perusal of this honorable court, my lord, I would like to show the medical report.
After some time. Yes.
Medical report that is annex, page 5 of the, my, this paper book. Page
So,
number 5.
whether any 164 statement is recorded,
Yes, ma'am.
that page number,
Page number 11.
page number
11.
11.
11.
And 161 statement,
161 is, my lord. Twenty-four.
whether the original record was called for.
Learned PP will know that.
Original record is available. Original record. Huh? It's in government. No, original record will be required. On the basis of scan copy, we cannot finally hear and dispose of the matter. Whether the 161 statement is available with you? Not available. Mr. Son Learned Amicus Curiae, perusal of the case diary is found to be necessary, and accordingly, case diary and the original case record is found to be necessary, and accordingly, it is provided that registrar shall call for the original record from the learned trial court, fixing the matter up. Fixing the matter on Friday then? Next Friday
Yes, my lord.
or
Friday.
Thursday? Next Thursday?
Yes.
Next Thursday. List the matter is ordered on Thursday.
Obliged, my lord. Please, my lord.
Yes.
I may be allowed to withdraw this petition, my lord. The petitioner don't want to pursue this case, my lord.
Petitioner?
I don't want to pursue this case, my lord.
Okay. Heard, Mr.
M. Ratan,
M. Ratan, learned counsel for the petitioner.
my lord, liberty may be.
Mr. Ratan submits that the petitioner is not willing to pursue this matter, and as such, he may be permitted to withdraw this petition. Uh, Taking note of the submission of learned counsel for the petitioner, this court deem it fit and proper to allow him to withdraw this petition, granting liberty to oppose the court again by filing appropriate petition.
My lord, there is an interim that may be vacated, my lord. Interim is there, interim.
Interim order stands vacated.
Deeply obliged, my lord.
Please. My lord, here in this case also, the PCR was called for the last occasion, but the cost list
LCR has not
reflected
been
the,
received.
yes. PCR, cost list has not shown any.
Heard. Heard Mr. C. Modi, learned counsel for the petitioner, and Mr. Z. Tado for the respondent. State respondent. Office note dated 27/5/2025 indicates that LCR has not been received. Accordingly, it is provided that this shall issue reminder to the learned trial court for transmitting the record without further delay. Case record without further delay. List the matter. After a week,
Well,
Obliged.
Number 16.
May I plead your lordship?
well, I'm for the respondent number 4. So I'm appearing for the first time and I'm filing my Wakladnama as well as trying to file my affidavit in opposition. So my lord, I need to 2 weeks time to my lord.
2 weeks time.
So, my lord, today we are seeking for a interim prayer, my lord. This may be considered, I'll not take much time, my lord.
Para 13, madam. Para 13 and 14, madam, this honorable court has sought some documents. Of order dated 1/5/2025.
So, though initially you have been appointed, at Tawang, director, you have been transferred to Roing.
Yes, ma'am. And at Rowing, my lord, I have not even completed my normal tenure of posting, my. And my lordship, this respondent number 4, he was initially transferred and posted to 0, ma'am. But
And in the on 22nd of February 2024, you have been absorbed as TA,
yes,
IWP under DRDA Roing.
yes, ma'am.
So what wrong with the impugned order?
My lord, my lord, this impugned order, my lord, has not been issued on public interest, my lord, but on outside influence. Because, my lord, this private respondent number 4, he is not even eligible to take charge of APO. There's a standing government notification, my lord, whereby it is also clarified that to be observed in the post of APO, one has to be to possess the degree of technical assistant, my lord. And the respondent is not even a technical assistant. He's a extension officer. And, my lord, in my transfer and posting order at page 20, my lord, may I read? I am directed to convey the government approval to allow Sri Yora Binam, TA, to add APORE DRDA rowing till regular APORE is posted, my lord. Till regular APO. He is not even a regular APO, and he is not even eligible to hold the post of APRO. Because
So where you have been transferred?
Lordship, I have not been posted out of rowing, but the posting of this private respondent number 4 as extension officer is not
So,
disputed.
this annexer 4 is the impugned order,
Yes,
right?
yes.
So you are still in Roing.
Yes. I'm already there taking the charge of APO, my lord. And only if the post is vacant or if there is no lordship, no one to look after the post of APO, only then they can accommodate the private respondent, my lord. Where I'm already looking after important projects like Manrega, my lord.
Maybe after absorption, whether you can continue in the earlier post.
Sorry, my lord.
You have been absorbed in the same department.
Yes, my lord. Sir. But the post is different, man.
Post is different.
Yeah.
Then how can you claim to that post, APORE?
My lord, as per government notification, my lord, which is still in force, I am eligible.
Maybe. Yes, so what is your instruction?
My lord, may I kindly see, my lord, page 20, my lord, of the petition.
Page 20.
Yes. Annexure 2. Well, he was given to look after the charge of APORE. His substantial post is TA, my lord. Technical
Substantial post is
technical assistant, my lord.
technical assistant.
And he has been absorbed as a technical assistant only, not as an APORE. So, my lord, so a person to look after the charge of APORE does not have any right, my lord, vested right to continue the post, my lord.
Yes.
So first thing, my lord. And then, my lord, regarding the interim of page 22, my lord.
Page?
22, my lord.
Yes.
My lord, this order was on 4th January, my lord.
Hmm.
They have come before this honorable court of this May, my lord. After a long gap, there is a delay. And then, my lord, there is an office memorandum. We have one office memorandum regarding, my lord, deployment of personnel, my lord.
Hmm.
Now, my lord, this is of 20 May 2003, my lord. My lord, may kindly see. It is only the extension officer, RE, my lord,
Hmm.
who can hold the charge of, my lord, APORE, my lord.
Hmm.
Private respondent is EORE.
Hmm.
Okay. Now regarding the qualification, my lord. My lord, I have submitted, my lord, private respondent is a degree holder, my lord, in engineering, my lord. I have submitted, my lord.
Hmm.
And then, of course, my lord, this 29 January 2019, there is a office memorandum, my lord.
Hmm.
This degree certificate regarding the engineering wing, it is not required, my lord. They are exempted from degree, my lord, degree holder, my lord. My lord, let me see.
So, my lord,
Oh,
at this stage, my lord, without entering into the, my lord, merit of the case, even in the interest of my lord, without causing any prejudice to both the parties, my lord, status quo may be allowed to maintain, my lord.
No, no, no. You were in officiating position there. So you have no right to claim that post.
yes, ma'am. He has been only given in to look after the charge of APORE. So he has no right.
Then only to look after, then he is not officiating also.
Yes, my lord.
Lordship, this respondent number 4 equally, my lord, is.
Okay, we'll finally hear and dispose of the matter.
Yes, ma'am.
Let them file affidavit.
Yes, ma'am.
Mr. Modi, when you will be filing your affidavit?
It will take at least one week time.
1 week time. Heard Mr. N. Padal, learned counsel for the petition. And Mr. Modi, learned counsel for respondent number 4. And Mr. Pisa for respondent number 123.
Yes, ma'am.
123. You have already filed your affidavit.
My lord, no, I have not filed. My lord. Only the instruction was sought, my lord. This honorable court has sought some documents, my lord.
Who filed this affidavit?
They have filed, my lord, they have filed additional affidavit, my lord. The petitioners.
Okay. Okay. Are you filing your?
Yes, my lord, we will file, my lord. At least 2 weeks time may be given.
No, 1 week time.
My lord.
Mr. Pisa also submits that he will be filing the affidavit in opposition, and he may be granted 1 week time. Where is accordingly allowed, recessal is the matter after a week. I have considered the submission of Mr. Pada, learned counsel for the petitioner, for granting interim relief. But having considered the facts and circumstances on the record, and also considering the submission of learned counsel for the respondent number 1, 2, and 3, this court is not inclined to grant any interim relief at this stage. List the matter after 1 week.
Hey, your lordship.
Yes.
Your lordship, the order I have put to challenge is order dated 26/5/2020, which has been passed by the additional deputy commissioner. Your lordship, the brief fact of the case is that the petitioners, they are the owner of the plot of land measuring it is approximately around 3,000 square meter. And your lordship, the land in question in this matter, it is a portion of that land. So your lordship, during 1970, 2 persons, one is the father of the respondent, and one more person, they beseech my uncle to temporarily reside there in our property, in my land. So your lordship, we allowed them, And however, your lordship, the father of the respondent, he started erecting permanent building in his temporary residence there. And also he started encroaching other land, other part of the land, your lordship. So your lordship, my uncle, he lodged a complaint before the circle officer, and as such, your lordship, a kava dated 4/10/1980 was cut, your lordship. That is in annexure to page number 21. May I read, your lordship? As per the order issued by CO Tirvin, byte number such and such, dated such and such, a kava was held on 4/10/1980 to decide the matter of complaint lodged by Sri Bilog Lombi against Sri Taitasar. Taitasar is the earlier respondent, your lordship, regarding the plot of land where Sri Taitasar has constructed a building for running his shop and the area wherein he has tried to erect fences for developing it as a kitchen garden. The Gauburas of the circle and members present passed the following decisions. Number one, the GBs of the circle and members present unanimously decided that Sri Bilog Lombi is the owner of Ruche Larjambike. This is the local name of my ancestral property, your lordship. And if the government requires the area in near future for any purpose, then the government should seek permission from Sri Bilog Lombi. Second, your lordship, in order to maintain social harmony and cordial relation, Sri Bilog Lombi shall give the plot of land where the building of Sri Taitasar stands to him free of cost, and the same has been accepted by Sri Bilog Lombi. Sri Taitasar shall give up the kitchen garden area. Then the area at the backside of that building shall be given to Taitasar, and the same has been accepted by Sri Bilog Lombi. So, your lordship, according as per this Kaba decision, your lordship, the area where he has encroached, he has erected his building, and just the backyard of that building, it was given to him, the respondent, for just communal harmony and to maintain peaceful relationship, your lordship. Thereafter, your lordship, however, the respondent, he started encroaching more areas, your lordship. So in 2001, and your lordship, in 2001, a kava was held. That you may, your lordship will find in page number 24, your lordship.
Yes.
Your lordship, in this case, in this kava, your lordship, I was not made a party, your lordship. May I read, your lordship? As per the order issued by CO Tirvin, such a kava was held on 1/11/2001 to settle the dispute between Sri Taitasar and Sri Takikai. Takikai is the other person whom my uncle and my father allowed to temporary residence there, your lordship. So, to settle the dispute between Sri Taitasar and Takikai regarding the area at the backside of the RCC building of Sri Taitasar, which was conducted within the family at the residence of Sri Taitasar in presence of the family members of both the parties and in presence of the family members of the landowners, Sri Bipak Lombi and late Bilog Lombi. In order to maintain social harmony and cordial relation between the parties, the Kaba members has passed the following decision. So apparently, your lordship, this Kaba was held to settle the dispute between Sri Taitasar and Sri Takikai. Both are not the landowners. Both were encroachers, and Sri Taitasar was gifted a portion of land. That's it. So, your lordship, the decision is as follows. One, starting from BRTA Main Road towards the pan in between the RCC building of Sri Taitasar and blacksmith shop of Sri Pagdam Lombi up to the stairs of RCC building of Sri Taitasar, and thereafter straight up to the Ruche stream has been demarcated by modifying the original Kaba decision, and the area at the Ruche stream side of Siru stream is declared as the lane of Pagdam Lombi. and in the area in the backside of the RCC building and Thai, starting from opposite boundary up to BRTF main road and upper side of granary building of Sri Taitasar up to BRTF culvert is to be retained by Sri Taitasar. This decision has been passed as per the Kava decision 4/10/1980 of Bilut Dombe. So, number two, after Peru Kava decision dated 4/10/1980, it has been passed that in the area starting from RCC building up to the Ruche stream, the area of BRTF road site is declared to be the land of Taitasar, and the area at the site of Ruche stream towards the part of the middle is declared to be the land of Pagdam Longbe. After passing the decision, the Kava have also decided that the area for construction of the house of Kilikai shall be decided by the parties among themselves. So, Your Lordship, the main Kava of 4/10/1980, where the respondent has been gifted a portion of land by me, it has been modified by this Kava, Your Lordship, by 1/11/2001. Thereafter, Your Lordship, being aggrieved, So, Your Lordship, this Kaba was supposed to be settled a dispute between the two respondent and one more person, Your Lordship. But here, Your Lordship, the earlier Kaba, in Kaba, it was modified without being challenged, Your Lordship. And we were not even made party to in that, Your Lordship. Thereafter, Your Lordship, despite settlement of the boundary in 1980, Your Lordship, the respondent he kept encroaching in my land, Your Lordship. Therefore, the petitioner make a complaint before the CEO again, and a Kava was again held on 27/9/2018. That is in Annexure 4, Your Lordship. And here also some modifications, and the earlier Kaba 1/10, the second Kaba, it was upheld. Thereafter, Your Lordship, the petitioners, they file a complaint before the ESC, and the ESC that passed an order dated 1/2/2019, that is in Annexure 6, Your Lordship, page number 38. Your Lordship, I'll just read the relevant portion. Page number 39, second para. In view of the above facts, based on reports and findings, the undersigned deems fit to direct Sri Pagdam Lombi to honor and comply with the Kava decision dated 27/9/2018 and to refrain himself from the act of obstruction and disturbances of Sri Taitasar while carrying out works at his plot, otherwise any illegal encroachment is done. Sri Taitasar is also directed to confine construction at his plot only. Further, both should maintain status quo and respect the dignity of each other so that a peace and congenial relationship is prevailed for the better cause of all. So, Your Lordship, meaning thereby the ESC also upheld the previous Kaba, Your Lordship. And without giving me an opportunity, without hearing me, Your Lordship, thereafter, I make an appeal before the Additional Deputy Commissioner, ADC, Your Lordship. And ADC White Order dated 26/5/2020, Kaba, Your Lordship. And I am aggrieved by this order of the ADC because, Your Lordship, it has mainly because it has not considered the order that was order of the Kava decision 4/10, Your Lordship, 1980, which was originally passed. And Your Lordship, that Kava that has never been assailed before any forum till that, Your Lordship. And So, Your Lordship, there cannot be any modification or alteration in that kava unless it has been challenged because Your Lordship, it has attained finality. Nobody has challenged that kava till that, Your Lordship. And Annexure 7 is the decision of the order of the ADC, Your Lordship. Your Lordship, I'll just read the relevant portion, Your Lordship. Page number 44. This is the observation made by the additional deputy commissioner. Page number 44, second para. From the statement of the appellant and respondent, examination of evidences and witnesses and available records in hand, it clearly appears that number one, the disputed plot is previously owned by Late Bilug Longbi. The land is ancestral land and a portion of land given to him as a share between two elder brothers, Late Vipak Longbi elder and Late Bilug Longbi younger. The ownership is not disputed here. Second, at later stage, during the lifetime of Late Bilug Longbi, out of love and affection, the present disputed land was gifted to Sri Tai Tasar without any material or monetary transaction during 1960 to 65. That is also wrong, Your Lordship. This is also a wrong thing because it was gifted to him only after 1980 in that cover. So thereafter, Your Lordship, number 5, Your Lordship, the disputed plot is under peaceful possession of Sri Tai Tasar without any disturbances for almost 5 decades. Then, Your Lordship, 7, in almost all the cover decision, the ownership right has been given to Sri Tai Tasar with some modifications. Without being challenged to the actual cover, Your Lordship, the rest of the cover and rest of the orders has been modifying the main cover order, the decision of the cover, Your Lordship. Number 8, a portion of land which is within the gifted land of Sri Tai Tasar, which is under the possession of Kili Kai, has been given to Sri Pakdam Longbi for the purpose of maintaining cordial relationship and social harmony and not on merit. Thereafter, 9, Your Lordship, there seems no scope of reasonable ground to give away entire gifted land back to the claimant, keeping only the portion of land under RCC and its backside portion, which comprise a small portion of the gifted and occupied land. The gifting of the land in question is settled during the generation, the lifetime of Late Bilug Longbi. So, Your Lordship, there was no other land gifted to the respondent except the building and its backyard, Your Lordship. So, Your Lordship, the observation that the ADC has made this point is also wrong because only the building and its backyard was gifted to the respondent, Your Lordship. And the rest, the entire land belongs to the petitioners, Your Lordship, and that is not disputed anywhere, Your Lordship. So thereafter, Your Lordship, the ADC thereafter, Your Lordship may kindly come to page 9, Your Lordship. Therefore, taking into account the aforesaid facts and circumstances in the interest of administration of justice, following orders are passed. The order and decision passed by the CAVA dated 27/9/2018 shall stand as is where it with the following modification. Second, the portion of land under occupation of Late Takikai, presently Kilikai, which was decided to be given to the appellant, Sri Pakdam Longbi, as per decision of CAVA, shall be immediately vacated by present occupant, which shall be owned and taken possession by present respondent Tai Tasar based on the boundary demarcated by the CAVA. So, Your Lordship, here again one more small portion of land where my uncle he allowed some other person to temporarily reside in that flat. That has also been, that area has also been passed in favor of the respondent. Then the CAVA 1980 CAVA was further modified, Your Lordship. A portion of land at BRTF roadside shall be parted out from the gifted an occupied plot of Tai Tasar in favor of Sri Pagdam Lombi appellant not on merit but only for the purpose of maintaining cordial and social relationship and peace and harmony between the parties, Your Lordship. So, Your Lordship, the order passed by ADC is, Your Lordship, arbitrary in as much as, Your Lordship, the ADC has not considered the order of the Kaba decision dated 1980, Your Lordship, which was the main Kaba, first Kaba, Your Lordship. And also, Your Lordship, since this is not disputed that I am the owner of the absolute owner of the land, and the respondent, they has just been gifted a plot of land, Your Lordship. So, Your Lordship, this ADC cover of the ADCs, it caused grave injustice in my favor, Your Lordship. And it is apparent that, Your Lordship, the order of the ADC, it is just like passed. It has been just been passed without, Your Lordship, by overlooking the evidences produced by me and not considered my evidences were not even considered, Your Lordship. Your Lordship, it is my humble prayer that the impugn orders dated 27/9/2018, 1/2/2019, and Your Lordship, the subsequent order of the ADC 5/2020 shall be quashed, Your Lordship.
Yes.
Why not you sit there because under Article 57? I don't like to get into all these, but something on merits. So they become the chair. But I want to be clear about that. There are things actually, there's no opportunity of hearing was properly given to the petitioner. That is our case in the clinic. For that matter, record may be required. I want to be clear from that. But otherwise, the manner in some cases, I don't think your lordship can interfere.
Pardon?
The manner in which the case has been projected, I don't think your lordship can interfere sitting in an Article 227 jurisdiction. Because the case of the petitioner, pleaded case is that the additional deputy commissioner, while deciding the appeal, did not give proper opportunity to the petitioner to produce evidence. That is a pleaded case. Now, as far as facts are concerned, under 227, how can your lordship, my lord, take it upon? The whole issue is admittedly in 1988, some person was given to the respondents. Thereafter, various decisions with the village authorities are there. All these village authorities have passed the decisions on the basis of the 1980 cover. Under such circumstances, there is no question of interfering under 227. What I'm trying to say is, if your lordship deems it fit, it is her pleaded case that no opportunity was given. If your lordship deems it records be required, that I'm not going to argue today. Otherwise, when I will place the records from here on. Her pleaded case is that no opportunity was given to produce proper evidence. It is her pleaded case.
Your Lordship, my main case is that, Your Lordship, the Kaba decision dated 1980, it has attained finality, Your Lordship.
No,
And the order has
okay,
to be.
okay. First, let him complete.
Your Lordship.
Yes.
In that case, my lord, kindly have page 32. I was trying to be fair to my learned friend actually. Then my lord will read this. Today, my lord kindly know, this is the that is initiated by the petitioner. Today on 27/9/2018, a Kaba was held under the chairmanship of Sri Sasensas Circle Head Gambura, strength of a complaint lodged by Sri Pagdam Lambu, that is the petitioner, the Circle Officer Office against Taita sir. He has passed away now been substituted. The Gaba under the chairmanship of Sri Kurdak Gadi allowed the parties to make their respective submissions. The complainant Sri Pagdam Lambu was heard by the Gaba. He stated that my uncle, let Biluk Lambu, gave me a plot of land at the upper side of the road. And I have no claims over the land given to Taita by my uncle. That is the plot wherein the RCC building stands and the area at the backside of the earth. However, I will not part with the other portion of the remaining land. So what is apparently trying to say is that a portion admittedly has been given to the respondent, the late respondent, but the late respondent is encroaching upon other parts. That appears to be the case of the petitioner. The Kaba also allowed, that part is accepted. The portion that has already been given to the late respondent. The Kaba also allowed the respondent Sri Taita sir to make his submission. He stated that this land was given to him by late Biluk Lombu, that is the uncle of the present petitioner, who in turn has given the other land to the petitioner. He stated they were given to us as a shared cordial relation and were affectionate towards each other. Later, in order to maintain cordial relation, the matter was also settled as family settlement. Later, Kaba members also demarcated the boundary in presence of Gaumburas. The boundary was demarcated from stairs straight up to the stream in the presence of Gaumburas and members. I have not encroached upon any area given to Pagdam Lombu by Biluk Lombu. So this is the dispute. Whether it encroached more than what was given to him. This is the dispute. I had claimed and when Ikai had constructed his house before the CEO, the Sri Pagdam Lombu did not raise any objection despite being present in the CEO office. Thereafter, I cited my claim what I said then before CEO office. But Sri Pagdam Lombu did not raise any objection then also, whereas you were present in the CEO office. So you tell the Kaba the reason for making the complaint now. The Kaba members also heard the sons of Biluk Lombu, both Sri Lukto Lombu and Sri Lukbu Lombu stated that we do not have any objection with regard to the land given by our father to Uncle Sai Sakar, the cousins of the petitioner, who are the sons of the original owner. The Kaba members, after hearing the complaint and responding also, the sons of the original landowner came to the conclusion that said Biluk Lombu gave the land in question to Tai Tasar out of affection. Therefore, the children of late Biluk Lombu and late Bipak Lombu have no reason to make any complaint. The Kaba members have arrived at this conclusion after perusing records of Kabas held earlier, meaning thereby the 1980 Kaba also. The Kaba members decided the plot where Kai's house then may be Sri Tai Tasar's land, but in order to maintain harmony and cordial with Tai Tasar, shall give away the said plot and let it owned by Sri Pagdam Lombu. In fact, that portion where the dispute was given to Pagdam Lombu, the petition. The Kaba members also decided the area for construction of Sri shall be given by Sri Pagdam Lombu, and the following members were entrusted to such and such. Therefore, said members demarcated the boundary as follows. He stated that the boundary is demarcated in this manner. From what transfers from this Kaba decision is that on the basis of the statements of the sons of the original owner and the earlier, taking into considering the earlier decision, this Kaba decision has been passed.
No, the question is whether an opportunity of being heard was given to the petitioner here. Whether an opportunity of being heard is given to was given to the petitioner in this Kaba.
Yes, Kaba given to dispute. Before the ESC, he said no opportunity was given.
No, she also submitted that this is of 27.
Second.
Yes, no opportunity. No, here also she submits that no opportunity was given to her.
Second Kaba, Your Lordship.
Yes. 27th of September 2018.
Kaba decision matter is not under children before.
This one.
Yes, Your Lordship, and my main case
But
is
this is the basis of the order passed by the
right,
ADC.
Your Lordship.
Maybe, but it is not under.
Your Lordship, my main case is that the Kaba 90 decision that was accepted by both the parties, me and the respondent, Your Lordship. Until that Kaba has not been challenged by anyone. If any if the respondents were not satisfied, they could have challenged that when I don't have any objection about the decision of that 1980 Kaba. One building and backyard of the building was gifted to the respondent. I don't have an objection to that, Your Lordship.
Let respect, my
But-
lord, how do your lordship decide that, my lord, in 227, my lord?
Your
Matter of
Lordship,
Fact,
Your Lordship, that
Based on
that all
evidence.
the considerations have been taken by the ADC, Your Lordship. So, Your
No,
Lordship,
the question is, we can examine whether the opportunity was given to the petitioner.
that is what I was
no, Your
saying
Lordship,
earlier.
Your Lordship, or opportunity in that
No.
case.
Possible to call for the
By
record.
going through this order of the ADC and also this decision of KEBA, can it be said that the petitioner was given the opportunity?
Second, Your Lordship,
Please,
second cover.
Madam, please.
That is why I was in the very initial.
No, that's all right. Going by this decision and also the order passed by the ADC,
Yeah.
can it be said that the opportunity of being heard was
Of the
given?
ADC, as far as written form is concerned, yes,
Given.
yes.
Your Lordship, in ADC, I have.
Yeah, I can show. Your lordship may kindly have page 40. Because this is the only document that is before the court service.
Pardon?
This is the only document that is before your lordship. the
Yes.
Page 40, my lord.
Hmm.
Initial appeal was, my lord, filed before the assistant commissioner against the decision of Biraj. Against that, under section 47, appeal has been filed before the deputy commissioner, come additional deputy commissioner. My lord will look. Under section 47 of the Assam Frontier Regulation 45, an appeal was filed before this appellate forum on being aggrieved by the impugn order passed by the extra assistant commissioner Leparata in such and such for setting aside the said order and declaration of title and ownership over the such and such land in favor of the appellate. Appeal petition and enclosures are examined thoroughly in the presence of the learned counsel, MS such and such. After thorough examination, it appears that the limitation period of filing appeal under section 47 was found expired. The petition not filed in the stipulated appeal period is liable to be rejected or dismissed. However, on the sincere pleading submitted by the counsel, a reasonable opportunity was afforded to explain as to why appeal filed before limitation shall not be rejected. Direction was issued to explain given point. Accordingly, learned counsel appeared and submitted it due to some unavoidable circumstances explained in detail. Petition could not be filed in a stipulated period. Alta counsel at length, taking into account the local difficulties faced in rural areas coupled with ignorance of established law, one being satisfied with the submission of the learned counsel, the delay was ongoing. My lord will kindly know, there was no agreement, even when the additional deputy commissioner was being very fair. So delay was condoned thereafter. Taking into account the spirit of the regulation read in section 96 of the Code of Civil Procedure, cognizance of the case was taken and directed both the to appear before the appellate forum with written statements in detail. Detailed written statements of both the parties submitted and heard the appellant and respondent at length, and further directions were issued to produce or adduce or present any material, documentary or oral evidence, if any, during next round of hearings. The gist of the case in brief is there. The plot of such and such, I am not going to bother, this is the factual part. Then my lord will see. Where was that? Page 43. Last part. I am not bothering with lordship with the facts at the moment. Hence, the present case is for the purpose of delivering justice under prevalent customary and traditional laws, taking into account the spirit of the provisions contained under various sections of Assam Frontier, the case was fixed for hearing on the following days. Such and such, 5 occasions. Both the parties heard at length. Documentary and medical material evidences produced before me has been examined. Witnesses also heard. So as far as the written order is concerned, it is reflected, materials examined, only the spirit is applicable, oral evidence taken, witnesses examined.
So, madam, you see this
That is why I was saying at
ADC
the
has a
outset If your
recorded
lordship calls for the
that
records of
both the
the,
parties were hard at length.
Your Lordship, I have never said that the opportunity was not given to me during the hearing of the ADC. I've never said that, Your Lordship. I have pleaded that the main Your Lordship, in second cover, Your Lordship, that is cover dated Annexure 3, Your Lordship. There I said that being the land owner, Your Lordship, I was not even made a party. So that was the basis of all the subsequent cover and the decision of the ADC. Again, in EAC, Your Lordship, I was not given the order by the
No,
EAC, Your
maybe,
Lordship.
but the ADC has given you the opportunity of being heard.
Yes, Your Lordship. I'm not denying that, Your Lordship.
Then ADC has also considered the evidence.
Yes, Your Lordship. That's why I'm aggrieved the I'm aggrieved by the decision of the order of the ADC because, Your Lordship, Your Lordship, the main observation, Your Lordship.
order is reflected the evidence were taken. But I have seen, my lord, additional deputy commissioner, they never record anything. Because calls for the record, therefore, I am making a very fair service of our land of plan. If it transpires from the record that this were not examined, maybe she has a case for filing a case before the appropriate forum now, if your lordship can set this order aside. At the moment, there is no question of setting it aside, my lord, because it is 227 application, my lord, revision application.
Your Lordship, Your Lordship may kindly consider the main observation of the ADC. Your Lordship.
Let us do one thing. Let the record come.
That would be helpful for the petition.
It will come from whose?
Basar,
Basar.
Office of the Additional Commissioner.
Basar.
Because-
Leparada.
Yes. 27, my lord. After there's a finding of fact, Supreme Court is categorical. It is not an appellate court.
No, that's all right. Or the court, revisional court cannot.
Yes.
But, Your Lordship, my case is not just limited to that, Your Lordship. I am not just saying that I have not been heard, Your Lordship. I have been heard. I am not denying that, Your Lordship. Records may be called, Your Lordship, but there are others, these also, Your Lordship, points also that
Let the record come, what do you say? Heard means E. Parme, learned counsel for the petitioner, and Mr. D. Pangling, learned counsel for the respondent. After hearing learned counsel for both the parties, perusal of the original record is found to be necessary. And accordingly, it is provided that the SSL call for the original record from the learned additional deputy commissioner, Leparada district, Basar. Fixing the matter after 1 week or 2 weeks.
I don't know, my lord, how much time it will take for the records to come.
Okay.
After receipt of that.
Okay, 2 weeks, after 2 weeks.
Yes.
Any day of-
no, please.
Di mang bago. Hindi ko ngayon ay ito na mga ito para may. Pero ikaw nung ito na siguro na.